Wagwan. Good morning, good night. Welcome back. And if you're listening for the first time, I'm your host Melanie Byfield, welcoming you to another episode of The Real Situation, where we give you a taste of Jamaican politics. Arsenal Football Club are Premier League champions and runners-up of the Champions League. I'm a long-time Arsenal supporter, since the 90s actually, mesmerised by the Arsenal's legendary second highest goal scorer, number 8, Ian Wright. Sporting my jersey now actually while I'm recording and celebrating the accomplishments of my team. We're the Premier League champions for the first time in 22 years, so big up the Arsenal. On to Jamaican politics, which is real hot right now. Nikisha Bertram, MP for Southern St. James, started her sectoral presentation in Patois and was told by the Speaker of the House that in the Parliament of Jamaica, she cannot speak Patois. Standing Order 6 says, number 1, the proceedings and debates of the House shall be in the English language, and number 2 says every petition shall be in the English language. While Patois is English-based, it's not considered English, so permission would have had to be granted by the Speaker to use it. Like when Orlando Terralong sought permission to speak Spanish for the benefit of the Cuban officials who were present in Parliament, and then Warmington losing mind. Cut a bridge and I speak Spanish. I mean, with all this talk about Jamaicanizing the Constitution, the standing orders need Jamaicanizing too, not true? Language is part of our culture, right? So Jamaican culture needs permission to operate in the Jamaican Parliament. Something for the standing order committees of the House and the Senate to look at, surely. What else I go on? National Reconstruction and Resilience Authority, NaRRA, is now law. And Jamaica's ambassador to the US, His Excellency, Major General, retired, Antony Bertram Anderson, former National Security to the Prime Minister, Chief of Defence Staff of the Jamaica Defence Force, and Commissioner of Police of the Jamaica Constabulary Force, will be NaRRA's CEO. The Gleaner reported a story I'm going to read a little bit for you. It's called Three of the country's largest business groups have endorsed Ambassador Anderson's appointment. The Jamaica Chamber of Commerce, the JCC, the Small Business Association of Jamaica, the SBAJ, and the Incorporated Master Builders Association of Jamaica, the IMAJ, described Anderson as a credible and experienced public servant with a track record of delivering results. Still, the JCC president said that he'd be closely monitoring the authority's operations. We certainly want to preserve the tax dollars and the loan funds and all the other sources of funds that NaRRA will be accessing to engage in these projects. And we certainly will be watching closely to ensure that there is proper oversight and proper audit function. We are also confident in the role of the Auditor General to provide oversight to public bodies, which includes NaRRA, he said. IMAJ president said Anderson has a very positive track record and has always come across as someone with integrity. We would expect that quite quickly there'll be an open and frank discussion about how locals will be engaged and how we will participate in the development, and also, very importantly, how Jamaicans will be empowered, whether through training, through some of the systems within NaRRA, or through some of the systems within NaRRA to be able to contribute to the rebuilding process, he said. However, he stressed that concerns about the NaRRA legislation remain, including transparency provisions and the absence of consultation with local contractors during the drafting stage. Okay, next, as for the Porsche on Jamaica's road to becoming a republic, it's still park up, meaning not now go on with constitutional reform. There was an article in the Gleaner, though, called Common Ground, Despite Republic Dispute, Parties Eye Consensus on Other Constitutional Changes, but Talks Yet to Resume. I'm going to read you a little bit about this article. It basically says 8 months into Jamaica's new parliamentary term, constitutional reform remains stalled as the governing JLP and PNP remain divided over how to amend the constitution. The key disputes centre on adopting the Caribbean Court of Justice as the final appellate court. And there are a few other things as well. So, but that's the main thing, obviously. The article goes on to say, despite the impasse, both sides say the constitutional reforms may still be advanced. The opposition leader is insisting that 64 years after the country received independence, it wouldn't be appropriate for Jamaica to seek to establish itself as a republic, but still have its constitution and laws interpreted and applied at the highest level by the King's Court in London. Mark Goldin says, this is an unacceptable anomaly which the opposition will not participate in. And since the government needs the opposition support to proceed with constitutional reform, we need to try to resolve this issue. And I think the place to start is a discussion by the two leaders of the main political parties to try and see if we can reach anywhere. The article actually clarifies why the opposition's support is needed by stating the following. Constitutional amendments affecting entrenched provisions require a 2/3 majority in both houses of Parliament. The government currently lacks that margin in both the House and the Senate, meaning support from the opposition is essential. And remembering before the election, the government did have a 2/3 majority in the House, which it lost. So now it needs 2/3 in both houses. The article goes on to say, despite the impasse over the final appellate court, both sides indicated there may still be room for consensus on other reforms. Goldin said wider measures such as stronger parliamentary accountability, impeachment provisions, recall mechanisms for members of Parliament and fixed election dates could proceed independently as they're not dependent on a resolution of the current sticking points. But on the issue of decolonisation, our position is well known, he noted. Chuck, as in Delroy Chuck, told the Sunday Gleaner that his ministry was looking at what could be implemented from the report of the Constitutional Reform Committee that was tabled in Parliament during the last parliamentary term, including proposals to constitutionally entrench the Electoral Commission of Jamaica and the Office of the Public Defender. But he went on to say that in my conversation with the opposition leader, he no want chat to me, he want chat to the Prime Minister, basically. So yes, the CCJ is still a firm roadblock on Jamaica's road to becoming a republic. We're going to be talking about reform from the perspective of constitutional expert Lloyd Barnett in the next couple of episodes. But we're going to start with an editorial by the Jamaica Observer, and it's called The Woeful Misapprehension of Dr. Lloyd Barnett, and this was actually written back in 2022, where they discuss their disagreement with his view on Jamaica having the CCJ as a final court of appeal. So they said, we stand by our view that most treacherous of all is those politicians who intervene to influence outcomes on their own behalf of that or connected parties. This is the great fear where a Caribbean Court of Appeal is concerned because the connections run deep from country to country. The view is that the law lords of the UK Privy Council are far removed from our everyday life and can afford to be dispassionate and as objective as humanly possible in rendering judgment. To lose that would be a fatal error. Now, the CCJ has been in existence for, I think, 21 years. Are there any instances of actual or suspected influence or a lack of independence that have been reported? I couldn't find a single one. But there is a case that is raising the question of whether the CCJ can truly stand above political influence. The Mohammed case is described as one of the most politically charged cases to come before that court. The Mohammeds are alleging that the authority to proceed, the ATP, which allows an extradition process to begin, was issued as a result of bias. There was actually a press release that was on the CCJ's website, which I'm going to share a little of with you. It's called CCJ Grants a Stay in Guyanese Extradition Matter. So it basically says, and I'm just taking some parts from it, the Caribbean Court of Justice convened a case management conference in the matter of Nazar Mohammed and Azruddin Mohammed versus Minister of Home Affairs, Attorney General and Magistrate of Guyana. The second appellant, Azruddin Mohammed, leader of the opposition of Guyana, and the first applicant, Nazar Mohammed, are the subjects of an extradition request made by the US government on October 30th, 2025. The request seeks their extradition to face an 11-count criminal indictment, including allegations of conspiracy, mail and wire fraud and money laundering. Following receipt of the request, the Minister of Home Affairs of Guyana issued an authority to proceed under the Fugitive Offenders Act. On October 31, 2025, Magistrate Judy Latchman issued arrest warrants, thereby commencing extradition proceedings in the Court of Committals, which remain ongoing. In December 2025, the applicants initiated judicial review proceedings against the Minister of Home Affairs, the Attorney General and the Magistrate, challenging the validity of the authority to proceed and seeking a stay of the extradition process. The claim was dismissed by the High Court on February 4, 26, and subsequently by the Court of Appeal on March 17, 26, with both courts refusing to grant a stay of proceedings. Against this background, the CCJ convened its first case management conference in the matter, which was heard via video conference on April 21. The CCJ panel comprised the Honourable Mr. Justice Winston Anderson, who is the CCJ President, and Madam Justice Rajnauth Lee and Madam Justice Ononayu. As confirmed in an article so that gave you a background of the case, right? And the proceedings. The Trinidad Guardian goes on in an article saying CCJ reserves ruling in Guyana National's extradition matter. It says the Caribbean Court of Justice reserved its ruling, right? Saying we are not yet in a position to give a decision on the application before us. Therefore, we are going to reserve until such time as we are able to do so, says the CCJ President Justice Winston Anderson. So that case is, that ruling is pending. Now, remembering the view, right, that the CCJ can't be independent or act without influence, right? I actually watched a podcast by Caribbean Tea, and it was called "Can the CCJ Stand Above Politics? Inside the Mohammed's Appeal." It's on YouTube. I will post a link to it on the podcast page, on this podcast page. And basically, they did a deep dive analysis of this case management conference, right? And in it, they examine the Mohammed's Appeal before the CCJ, the role of the minister, the Attorney General and the executive in issuing the ATP, allegations of political bias in extradition, the court's probing questions during the hearing, the constitutional implications for Guyana and the wider Caribbean, and whether the CCJ strengthened confidence in it in itself as a regional institution. I am going to conclude by sharing one of the hosts, Vivian Williams. I'm going to share how he basically wrapped up that podcast as follows. A question has followed the Caribbean Court of Justice since its creation. Can it be truly independent? Courts do not answer that question in theory. They answer it in cases like this. Cases where the stakes are high, where politics is close, where the pressure, real or perceived, is impossible to ignore. And in this case, what do we see? We see a court that didn't retreat into silence, didn't defer to power, and did not rush to judgment. We saw a court that pressed both sides with equal force, confronted difficult constitutional questions, refused to accept easy answers, and remained grounded throughout in the discipline of the law. For years, countries across the Caribbean have hesitated, some choosing not to place their final appeals in the hands of the CCJ, concerned about influence, concerned about independence, concerned about whether a regional court can stand apart from regional politics. But in this hearing, in the way the court approached the issues, in the way it challenged both sides, in the balance it tried to strike between law and political reality, there is something important to observe. For those watching and weighing the value of this regional institution, this hearing may go some way towards removing that doubt by showing that the CCJ is capable of acting as an independent arbiter, constitutional check, a court willing to challenge power without being shaped by it. So I leave you with these 3 questions. Can the CCJ stand above politics? I mean, what are the views of those doubting the court's integrity and ability to stand above politics, having reviewed this case so far? Can Jamaica's ambassador to the US, His Excellency, Major General, retired, Antony Bertram Anderson, command NaRRA to successfully undertake Jamaica's multi-billion-dollar recovery projects? Can the Porsche be repaired and put back on Jamaica's road to becoming a republic free of potholes and roadblocks? Time alone. As a reminder, if you're not registered to vote, September 30, 2026 is the deadline to register for the November 30th, 2026 voters list. You can find this podcast on YouTube, Buzzsprout, Spotify, Podcast Index, Deezer, Podcast Addict, Apple, iHeartRadio, and Amazon Music. If you want to reason about anything, or you can't find any of the material I was talking about, you can email me on melanie.atasteofja@gmail.com. That's melanie.atasteofja ofja@gmail.com. Until the next time, thank you for supporting this podcast. Please subscribe, like, follow, and share it with your family and friends. And again, I thank you for taking the time to listen. One love. Yes, the word is love.